But Bashan, it's so nice to see young little children. They were like 8th graders. And they're already taking advanced algebra in 8th grade. I'm like, okay. But everyone should be ready now because they have plenty, you all have plenty of time to confer. Diana, I am going to talk slow, but if I'm not talking slow, let me know. No. Okay, great. Okay. Yeah. Norma, do you have that? Can I have a copy of today's docket? I don't know where my docket is. All right, who's here on Justin Schermerhorn?
Good morning, Your Honor. Robert Featherston representing Mr. Schermerhorn.
All right. And he only has one case, correct?
That's correct, Your Honor.
One case, but yes, and then unindicted cases.
Okay. All right. Court is calling 2022 CR 6337, State of Texas versus Justin Schermerhorn. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Robert Featherston.
Are you Justin Schermerhorn?
Yes, ma'am.
Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Justin Scott Schermerhorn who was placed on community supervision in 2022 CR 6337 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on November 17, 2022 for a term of 5 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. Violated condition number 1 on or about the 17th day of April 2023 in Bexar County, Texas. The defendant, Justin Scott Schermerhorn, committed the offense of possession of controlled substance, penalty group 1, a violation of condition number 1.
How do you plead to that? True or not true?
Sure.
And Your Honor, that's actually for 4 different new number 1s. Would you like me to read it for each one?
Yes, please.
Okay. Violated condition number 1 on or about the 17th day. Jason. It's the same. 2023 in Bexar County, Texas, the defendant Justin Scott Schermerhorn committed the offense of possession of a controlled substance, penalty group 1, in violation condition number 1.
How do you plead to that? True or not true?
Sure.
Your Honor, we'll just waive the remaining violation.
Any objections to the state's waivers?
No, Your Honor.
Mr. Schermerhorn, did you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion, sentence you to 6 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1 and 1?
Yes, ma'am.
Court will find 1 and 1 true. Is there an agreement?
Yes, there is, Your Honor. It is to revoke this individual office probation, sentence to 6 years in the TDC, and also the state will take into consideration the night mag numbers 708902, 708903, 708904, and 708906.
That's correct, Your Honor.
All right. Mr. Schermerhorn, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right. The court will follow your agreement. The court is finding violations 1 and 1 true. The court is granting the motion. The court will sentence you to 6 years in the prison, taking consideration the following night mag numbers 708902, 903, 904, 906. There's to be no contact with Allen, Allen Martin, Martin, Felicia, Felisha, Reyna, Reyna, and Robert Perez Jr. Court will give you credit for any time served. Is there anything else with regards to sentencing from either side?
Not from the state, Your Honor.
No, Your Honor.
Mr. Schermerhorn, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, of course, because the court has followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, Mr. Schermerhorn, we can go off the record. You're going to have to start making better decisions in your life. Otherwise, you're going to find yourself in and out of prison. Do not be the oldest person at the prison. You understand?
Yes, ma'am.
All right, good luck to you.
Here you go.
Who is here on John Deaver?
I am your.
Do we have an update on?
We are back to case today.
All right. On Mr. Deaver, they're actually staffing his place today. So we're going to do a reset, counsel, because it's better that I have this information than not. All right, Ms. Ferguson, can we recall Mr. Deaver for next week? Yes. All right, so we're going to be back on. Yes.
We do it a couple of days before.
Let me ask you this. Are you out of town on vacation or?
No. I'll be in Del Rio to prepare for a capital murder sentencing.
Okay. Are you able to do it?
May I?
Yes.
They said that we would have a determination shortly after noon.
So are you able to come back this afternoon?
Yes, sure.
All right, so we'll see you back this afternoon, and let's see you back here at 3.
Yes, ma'am.
All right, so this is coming back at 3 p.m. All right, who's here on Tremonte Singleton? Tremonte Singleton, who's the attorney?
Oh, it's David Garcia. He's about to another court judge. He'll be right back.
All right, who's here on Yvonne Perez? All right, on this case, we are waiting for autopsy report. Is that correct?
Yes, Your Honor. And the medical examiner's office did indicate that the autopsy was completed on May 7th, I believe, and that they were going to have it uploaded into our system. However, I checked and it has not been uploaded yet. So I'm actually was in the process of drafting a follow-up email to the ME's office to find out where it is, but it is complete. And I think it's just a matter of getting our hands on it and we can get it to defense counsel right away.
And Judge, what I would propose, if we could just recall it for next week, that way make sure that we have it, we can sign the discovery acknowledgement and hopefully get an offer from the state at that time.
All right, state, would you be prepared to make an offer next week or no?
That might be a little too soon. I would request at least a couple weeks.
All right, so we'll come back in 2 weeks. Ms. Ferguson, I need a 2-week reset for discovery and for the state to make an offer on Yvonne Perez, please. All right, so we're going to come back on June 8th. Is that a good time for you, counsel?
Yes, that should be fine, Judge. Thank you.
All right, we'll see you then. Here's this one. All right, Tremonte Singleton.
We're ready, Judge.
Where's Mr. Singleton?
He's coming.
All right, thank you. Hello. Court is calling 2022 CR 6777, State of Texas versus Tremonte Singleton. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
For the defense?
David A. Garcia, attorney for Tremonte Singleton, judge.
And are you Mr. Singleton?
Yes, ma'am.
All right, Mr. Singleton, you entered a plea
Yes, ma'am.
on March 30th to aggravated sexual assault. According to the plea bargain agreement, punishment is to be assessed at a cap of 10 years. The state opposes your application. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
We have.
All right. Any objections, state?
No.
Defense?
Judge, the only thing that I would add is It's left out that one of his priors was out of Houston. And it was an indecency with a child where he served 5 years prison.
Okay.
I wanted to bring that up because my clients can talk about that. Secondly, when they asked about the incident, because it was 21 years ago, my client was kind of in shock trying to remember, but and you'll hear from him when he testifies, Judge, but he's very sorry about what happened. And that was left out of the PSI report. Other than that, we have no objections.
Okay. State, do you have any witnesses?
We do not, Your Honor.
Defense, any witnesses?
No witnesses in person, Judge. I tendered to both the state and to your clerk 4 letters from family members.
And the court is in receipt of the letters. Any objections to the court reviewing those letters, State?
No, Your Honor.
All right, the court will review the letters. All right, the court has reviewed the letters. Any argument from either side? States you're opposed?
Well, Judge, my client would like to speak.
Oh, okay. Could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record, please.
Tremonte Singleton.
All right, defense.
Tremonte, you stand now before the judge. This incident happened back in 2002, correct?
Yes, sir.
Okay. Never once when we talked from the first moment that we met till today, did you ever intend to fight this case? Is that correct?
No.
Because you knew you did it.
Yeah.
And in fact, you went to prison out of Houston from 2009 to 2014, correct?
Yes, sir.
For an incident that occurred in Houston
But they
back in 2002. Okay, and while they were investigating that incident, you also got notice that they were investigating this incident out of San Antonio, correct?
Right.
Okay. So when you took your plea in Houston, you had never met me, right?
No, sir.
And so you took your plea in Houston, you did your time, you did almost the whole 5 years, correct?
I did the whole 5.
And when you got out, you thought both of these cases were long gone, correct?
Your Honor, I object to leading.
All right, that'll be overruled. You make.
I'm just trying to speed things up there. So when you were arrested on this charge, you were shocked, correct?
Yes.
In fact, wasn't that basically what you were telling me the first time we met? You couldn't
Yes.
believe that this was happening, that was in your past and you thought you had taken care of everything.
What I would like to say first, I apologize. And I'm very sorry to the victim if I hurt him or anything caused any harm in their life. I sincerely apologize for it. But when I was arrested in 2009, I was made aware of this case. And all I want to do is just get everything out the way. And I asked them about when was I coming back here to face punishment or whatever for this case. I went through 5 years, never got expedited, never got a bench warrant from TDC, never had a detainers from the wall. I stayed out another 8.5 years, registered, done everything I had to do, and I didn't know that this case was still about me until they picked me up in 2022. And I had asked them about this particular case way back then, and there was never no warrant, no nothing until now.
Now, Tremonti, when you said you reported as a sexual predator every year from 2014 up to 2022, correct?
Yes.
You never got into any trouble from 2014 to 22.
No.
Okay. During that time period, you had children, didn't you?
Yes.
You had a job. You were gainfully employed.
Yes.
You were trying to be the best citizen you could.
Best dad, best brother, best son, best everything I could be. I wasn't trying to be the person I am now. You know what I'm saying? It was from 21 years ago.
And you would have been gainfully employed except you got hurt on the job. Is that correct?
Yes, I am. I'm legally disabled to my right wrist because I got my hand crushed by some pipe.
And in fact, you're still awaiting surgery on your elbow, aren't you?
Yeah, elbow.
You receive about what, $1,500 to $1,600 a month on disability?
Right at $1,600 a month from Liberty Mutual, being disabled.
And you have 5 children?
5.
Okay. 2 of which you are intimately involved with?
Yes.
Helped raise?
Yes, sir.
How are those kids doing in school?
Doing great.
One of them's honor roll?
Yeah,
Your 16-year-old?
I is on the road. So.
And your younger son, he's making good grades?
Yes.
A's and B's?
Yes, sir.
The other 3 kids, you don't have as much involvement because of their mother, correct?
Exactly.
But do you try to help support them?
Of course, yes, sir.
Anything you can.
Best I can.
Okay. Now, you know the judge can send you to prison for up to 10 years.
Yes, sir. I understand that.
Or she can give you deferred adjudication for up to 10 years.
I understand that.
If she were to give you deferred adjudication, why would she do that? You have this horrific past. Are you the same person you were back then?
No, sir. I'm not the same person I was.
Does the fact that you've stayed out of trouble since 2014 help show that you're a different man?
I would like to think that, but like I said, it's only, you can go by only so much, you know what I'm saying? I know in my heart that I'm not that person from 14 years ago. I never want to go back to being that person.
Would you do anything the judge requires you?
Anything.
If she sends you to jail, you understand.
I understand that.
And you respect that. But you're hoping she gives you this opportunity. I'll tend to the witness.
State.
Mr. Singleton, who is the victim in the case from Harris County?
Her name is Nick.
What was your relationship to her?
Didn't have a relationship. Me and her stepdad, we were kind of like friends.
So were you a family friend of hers?
No, not a family friend of her. Just knew like living in the same neighborhood and stuff, but I didn't know her.
Was it a similar situation as this case where you assaulted her in public?
Mm.
So this happened in a home?
Yes.
What, you were in a position of trust?
You per se, yeah.
Okay. And how old was she?
15.
Okay. So she was the same age as the victim in this case.
Yes.
And you didn't know the victim in this case, did you?
No, I didn't even know her age until after I got arrested here.
Okay. Now, you knew you had committed this crime, right? When it happened, you knew it was a crime.
I didn't know that I got charged with this crime until 2009 when they questioned me about it. I didn't actually know that I was even charged with this until I got arrested.
So you thought you got away with it until you were arrested for it?
I thought I got away with it. I just never thought it was. I was never arrested for it, so I didn't know that.
Object to non-responsive. You knew it was a crime when you raped her in 2002.
I didn't. Well, if that's what you want to say, yes.
Okay. So did you go to the police in San Antonio and turn yourself in and say, I just raped a 15-year-old girl?
No, because their circumstances of what they're saying and what I need to be the truth never got put out there. I was never interrogated, not even here, not even in Houston. barely. They just asked me a few questions about it. I was never interrogated. I was never able to tell my side of the story.
Okay, so now you're saying that you weren't actually, it wasn't an investigation and you knew that the charges weren't actually pending.
No, I didn't know that. No, it was an investigation or nothing. I didn't know nothing about this case until I got to Harris County. When I got arrested in 2009, I didn't know nothing about this case.
Okay. It wasn't until 2021 that San Antonio Police Department actually came and served you with a warrant to get a sample of your DNA, correct?
No, they did not get an initial warrant out to get a sample of my DNA. They already had my DNA in 2009 when they questioned me. They had already had my DNA.
Are you saying they didn't come and get another swab out of your mouth?
No. They did a yearly swab.
Okay.
A yearly swab as I was registered.
Okay.
But they already had my DNA in 2009 when they questioned me. Because that's how I got alerted to the case in 2009 when they told me that I had a DNA match back then, 14 years
In
ago.
2009, did you try to find out the name of the victim from 2002?
They told me tonight.
Did you ever try to reach out and apologize to her?
No, I was being incarcerated at the time. I was on my way to.
Did you make any attempts?
Didn't make any. I didn't know. I barely even knew. That was like, you talking about something that happened in 2002. This is 2009. I'm talking about it was 7 years before I wasn't even in San Antonio at the time.
Okay, but you got your GED while you were incarcerated, correct?
Yes.
So you had access to people who knew how to look into information. People from the outside world.
I'm going to object to vague, Judge.
All right, well, this is the question the court has. I want to know why a charge that happened in 2002, and I understand the honor about dates and the indictment is honor about 2022, but I want to know why something that occurred in 2002, he's in prison, everybody should know where he is, he's at the prison. Why is this just being addressed now? That's what I want to know.
So Judge,
no.
we discussed that. I discussed it with my client. I discussed it with the state. I told my client that we could file a motion for speedy trial, that the detectives, the state dropped the ball, that this all should have been taken care of back then, but he did not want to do that. He knew he had done it, wanted to go forward, but just wanted to let you know that he had spent 5 years in prison thinking that all of this was taken into consideration when it clearly wasn't. And so I think that's one of the reasons why the state made this offer, because we discussed this, we worked everything in, but we wanted to bring it to your attention so that you knew that that was an option. He didn't want to go with that option, Judge. He just wanted to come up, let you know what had happened, and hoping that you'd give him the deferred.
All right. Well, I'm not going to give you deferred adjudication. I am going to find you guilty. So the issue that needs to be discussed is with regards to the offer of a cap of 10 years and the sentence that I give him. There needs to be, I guess, an investigation or law needs to be pulled on what time he gets credit for.
Well, I would ask that he gets credit for all 5 years, Judge.
Your Honor, if I could just say something, technically he was not, an arrest warrant was never walked. He was, the first time a warrant ever went out for this case was when he was indicted for this case. So as far as speedy trial or anything like that, I mean, they didn't have enough to indict until they did a comparison. So it wasn't just the CODIS that he was indicted on. They did another swab.
See, but here's the thing, Judge. They had his name. They had his location. If they had done any real investigation, they would have been able to find that he took this plea in 2009 and was reported, you know, they had his DNA. So I understand their point. And this is one of the things that I explained to my client, because they did not walk the arrest warrant, but they knew all of the factors. And it wasn't like he went anywhere. It's not like he ran. He was there the whole time. In his mind, he had worked this all out, was going to prison so that when he was done, he could start his life anew, and he did. He is the poster child of our rehabilitation system. He got out, he reported like he was supposed to, he got himself a job, he got himself a community with his mom, his aunt, his neighbors. You read some of those letters. I mean, his daughters think the world of him, okay? Because from that point on in their world where he lived with them, he was the perfect father. He did everything he could for his children. And I submit to you, this is what we want from our justice system. We want people who make huge mistakes, and he did, Judge. He's not denying that.
Well, what I can tell you is the court thinks it's morally wrong. Notice I'm not using the word legally, but I think it's morally wrong for people. And I know it wasn't this prosecutor. I think it's morally wrong for people to know that people are at the prison. And then when people get out, then bam, we're dropping a case on them that's been in existence and been out there. And I know, Ms. Mitchell, you were not a part of that. So I am going to find him guilty. And if anybody wants to do research on what credit for time he should be entitled to, maybe we may be making some new law here. Let the court know, and counsel, if he is able to get credit for the time that he was at the prison. You say the 5 years?
Yes.
If you bring the court case law for that, the court will consider giving him time for the 5 years.
Yeah.
So if someone brings that to me, I will make sure that he receives that. Mr. Singleton, I'm going to tell you, I understand that you have changed your life, and it seems that you've changed your life for the better. And I understand that you thought that all of these cases were being taken care of when you took care of the other. I've read the stipulations. I always reread the stipulations, and I always read the PSI report. So I know the circumstances behind this. And I never blame complainants for anything that happens to them, because you're living your life. You're not breaking the law. Nobody's supposed to break the law where it impacts and hurts you. But I saw the circumstances behind everything that's in the stipulations. The drug use, which is the drug use by you, and the complainant who's underage, which should not have happened because she's underage and you should not be using drugs with her. The mother who is, and father who are not watching her the way they should watch her. So there are a lot of things that would. Could somebody help Miss, yes, with her phone? Thank you. So I understand there are a lot of issues going on, but at that same token, this is the plea bargain agreement you entered into, okay? The court is going to find you guilty. The court will sentence you to 10 years in the prison. The court will give you credit for any time served and defense if you bring me documentation of the amount of time that he served in prison. And if the law says that I can give him that time, then of course he will receive that time. If you think he should get that time and you want to file an appeal on that for him to get that time, just let the court know. And I know you're court appointed. Is that correct?
Correct.
You can be court appointed to address that issue as well.
Thank you, Judge.
All right. Going to show you. Oh, and I'm sorry. There's also Chapter 62 registration. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it? All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I have one question.
Yes.
You said if they find out that I was already locked up, I was interrogated about this case out of Harris County. It said I have an audio tape interrogation out of Harris County about them questioning me about this case, about them calling here saying that we have him in custody in Harris County, out of Harris County on this case. All
right. Counsel, do you have that information?
We have that information, Judge.
All right. So if you present that, and again, if based upon the law, if I'm allowed to give you credit for that, I will. Okay. I don't know offhand because I don't have all the information about who knew what and when they knew it. I know that you're saying that they knew it and your attorney's saying they knew it, but I actually have to see the evidence for that. And if that's presented to me, and if case law says that I can give you credit for that time, I will give you credit for the 5 years.
Yeah, because when they initially, before I initially turned myself in, I had the case out of Harris County, and they told me I had a case pending out of San Antonio, which my DNA was a match in 2009. And when I turned myself in, after I got the 5 years out of Harris County, I asked the judge, when were they going to send me back to San Antonio for this case? So I've been know about this case. I've been know about this case since 2009. And I thought that they would have came and expedited me, since they took my DNA at TDC after I took the time. And they took my DNA also when I got out of the walls. Okay. I never had a detainer.
All right. So Mr. Singleton, just give that information to your attorney. And again, if the case law says that I can give you credit for that, I will. All right. Thank you.
Yeah. So it's a case law. That's what you said.
Who's here on Angel Cruz?
I am, Your Honor.
Yes. Hello. Top of the morning.
Top of the morning, Jack. Mr. Cruz is present. He has an MTR. He also has a new case. We're discussing, the DA and I are discussing a resolution for both cases.
Okay.
However, I've not sat down before today with Mr. Cruz about the new case. I'm asking for a reset to give him time to review the.
All right. And the new case, is it indicted?
It's not indicted, but
it's unindicted, Judge, but I did make a pre-indictment offer.
Okay. And you're on both cases, Mr.
yes,
Wood?
Judge.
All right. Where's Mr. Cruz? Have him come forward.
Right.
All right. How much time are you requesting?
30 days
Okay.
or less.
All right.
Whatever you give me.
All right. What is the new charge? Mr. Cruz, come forward. All right. And the new charge?
Burglary of a building, Judge. It's not a habitation.
Oh, I'll give you 2 weeks. It's a burglary of a building. Okay. All right, Ms. Ferguson, can I have a 2-week reset on Angel Cruz for a disposition?
I would do June 12th.
Is June 12th good for you?
Sure, Judge. Sure.
All right. After you sign the reset form, you're excused. Thank you.
I'll get it ready.
Thank you, Judge.
Oh, I like anime too. All right, who is here on Tyrone Shepherd? Where's Mr. Shepherd? All right, so what is happening with this case?
The state has considered a plea offer that I've discussed in part with my clients. Over the course of that discussion, other issues have arose. I've filed a motion into this case to have my client reassessed for competency.
All right.
I'm asking the court to do that, to order that today.
All right, Ms. Ferguson, can you make sure there's an expedited competency evaluation done with Mr. Shepherd?
Yes,
What date are we bringing this back?
I can do June 22nd.
All right, we're going to come back on June 22nd. Mr. Shepherd, since you're on bond, you need to make sure that your attorney has your information so that they can contact you to speak with you, okay?
Yes, ma'am.
All right, after you sign the reset form, you're excused. Thank you. Who's here on Justin Galinda?
I am, Your Honor.
All right, if you'll come forward. All right, thank you. Felix out. All right. Who's the attorney on that?
Yeah.
Can I see the file on Felix Apollinaire? I don't know if they've turned it.
I've taken another look at the books, most of them.
All right, Mr. Stateston, is this an application?
Application for deferred.
All right.
Yes.
Probation, this is an application. Court is calling 2021 CR 11622, State of Texas versus Justin. Is it Galena or Jelena?
Galena.
Galena. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Joseph Stateston, and I was appointed Monday, but I had been on a prior case, a different court, more than 10 days on the other case. But we would be asking to waive the 10 days, and I explained that to my client, and he was in agreement to waive the 10 days notice.
All right, is that correct, Mr. Galena?
Yes, Your Honor.
Counsel, you received all the discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery, showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Showing you the true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
You are, Your Honor.
Mr. Galena, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged by indictment with possession of a controlled substance, penalty group 2, 4 to 400 grams? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could sentence you up to 20 years in prison and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Galena, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $2,000 fine. State recommends deferred adjudication, and there's to be restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State exhibit number 1 with all of its attachments.
Any objection?
None.
And state, you may be excused. Mr. Galena, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witness statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, and I did speak with the prosecutor. Mr. Garahan did allow us to go open with 1 term, the community service hours. He recommended 200. We were requesting less hours. We were going to request around 120 hours, but my client's 25-year-old. This incident happened because of a seizure. It wasn't that he was going down the street dealing drugs. It just was a medical issue that somebody called for emergency services. We're not denying that there are substances there. He'll tell you the substances were there, but we're asking based on his age. He did have some minor prior criminal history. They're recommending defer, but we're asking for 120 hours community service. And he does live here in Bexar County, but he may be moving. He may go to Floresville. He wants to report here for now, but he just wants the court to know if he does move, he may want probation transferred in the future.
All right. Are you employed?
No, ma'am. I put in my 2 weeks notice before I turned myself in.
And what were you doing?
I worked for Capital Title of Texas, examiner.
All right. So you're doing that and then have drugs at your house?
Well, this was from 2021.
He's changed.
Yes.
Yes, Your Honor. From that day, yeah, I quit everything.
Do you have any children?
No, Your Honor.
Do you have family support?
Yes, Your Honor.
His mother, and she has been calling me. I spoke with her several times.
Calling you a lot?
Yes.
All right. This is what, well, before you were arrested, when is the last time you used drugs?
I've still smoked marijuana, but maybe 2 weeks before that, probably April 30th, whenever I moved everything up instead of a storage unit.
April 30th of what year?
2023.
All right. You're not allowed to smoke marijuana while you're on probation, you understand?
Yes, ma'am.
What is your medical issue?
I believe that was a one-time occurrence. He does not expect future seizures to happen.
It was withdrawals when I had me
from drugs.
Okay. That's whenever I stopped doing those drugs.
All right. 4 years deferred adjudication, $2,000 fine that'll be probated, restitution to SAPD, 160 hours community service restitution, proof of employment within 30 days, no employment as a home health care provider with minors, regular reporting by Zoom or in person. We're going to do the UA hotline, test for levels. We're going to do 90 sober meetings in 90 days. We'll do a TAP evaluation. That can be out of custody. If the TAP evaluation recommends inpatient treatment, we're going to start with supportive outpatient treatment and see how that goes. I'm going to want field visits 1 time per month until further notice. Probation, is there anything else he needs?
Your Honor, did you say 160 hours of community service?
Yes.
Nothing else, Your Honor.
All right, is there anything else you need from the court to be successful?
No, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, in this, we can go off the record in this court. To be successful on probation, communication is key. If you're having an issue in your life, contact probation. If probation, you feel like they're not addressing your issue, then what you do is you come to court. We're here Monday through Friday. All right. Good luck to you.
Thank you, Judge.
You're welcome. Who's here on Alejandro Trevino? And on this case, the state was to speak with the complaining witness. Is that correct?
Yes, Your Honor.
All right. What is the status?
The state provided the plea offer this morning. We worked out the details. I would like to be reset for the plea deadline date so I can meet with my client in my office to be able to review all the details and for him to come back to the court with a final decision.
All right, Mr. Trevino, how old are you?
I'm 26.
All right, Ms. Ferguson, on this, I need a plea deadline date within 2 weeks, please. All right, we'll see you back on June 12th. Get a reset form from Ms. Ferguson, and then you're excused. Who's here on Xavier Garcia? Xavier Garcia, come forward. And this is criminal trial division. What's the status of this case?
Judge, so this defendant does have a deadly conduct firearm charge that is sealed. I just saw this feeling whenever I spoke with defense.
All right, Ms. Ferguson, on this case, can I have a reset date for 30 days?
Okay.
And are you appointed counsel?
Yes.
All right, so you all need to confer off docket on that deadly conduct matter.
I work, Judge.
All right, what date, Ms. Ferguson?
22nd.
All right, we're going to be back on June 22nd. We will see you then. After you sign the reset form, you're excused.
Thank you. Just so the court's aware, we have already started to make attempts to reach out to the complainant. So that's already in the process.
All right, thank you so much. Joshua Kaniagwa. Who's here for Joshua?
Tony Jimenez.
Oh, thank you. Tony, I promise you, I'm going to learn how to say your client's last name. I can't put those letters together. It's a lot of vowels.
I have problems myself sometimes.
Okay. All right. We're supposed to address. I can't read my own writing. What are we here for?
His violation report was for.
Yes, that's it. That's the writing. It says violation. Thank you. So we're supposed to address the violation report. So are parties ready to address this?
Well, Your Honor, we have made multiple attempts to contact the victim and we have not been successful. So
there are two people who are in the waiting room. Is there someone waiting for someone in the waiting room?
I don't think there are.
Defense or state? Thank you. So it's with probation. All right, we're going to go on the record in 2023 CR 3067, State of Texas versus Joshua Panuaga. Can I have parties? I know. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
Tony Jimenez.
And say your complete name so I can get it correct.
Joshua Panuaga.
All right. Say that, Mr. Jimenez.
Panuaga.
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 Like bread and water in Spanish.
Panuaga.
It's a Y. Panuaga.
Okay. Thank you. May I call you Joshua? But I promise I'm going to work on the last name. I always treat everybody with respect, but sometimes the last name, I can't roll the letters together. Okay, I'm working on it. So we're here on a violation report, and he has a burglary of a habitation, and then I have a violation of a bond protective order, and that came after the burglary of a habitation. And so the court was asking that the complainant appear so that I could make a ruling on this, and state is saying that they're unable to contact the complainant.
Yes, Your Honor, and I made attempts to contact her myself, was unsuccessful in my attempts. The last time we were here, he was explaining to you that he received a call from his 9-year-old son that he wanted to visit his father. He went ahead and made arrangements. The complainant mother got on the phone, told him to go ahead and come to the house to visit their 9-year-old son. He went over there, and when he got there, he actually called the police and said he was at the residence to visit his son, and the police made the scene, and they arrested him for violating the protective order. That's why we're here today on the violation, and that's my understanding of the violation.
All right. Sir, based on the fact that the state has not been able to get in touch with the complainant based upon your representation of your counsel, what I'm going to do, if there's no objection from the state, I'm going to have to put you on full house arrest so you can understand that you're not allowed to have contact.
How am I get a hold of my children?
That's going to have to be through a third party.
That's fine.
So your grandmother or your mom, they can call over there to see how everything, but they can't call over there at your direction.
Yes, ma'am.
But they can call over there and see if the complainant is doesn't have an issue with the children coming to visit you wherever you are, but you're not allowed to go over there anymore. Do you understand?
Yes, ma'am. What about the custody order agreement? Am I still able to pick them up in school?
I'm going to address all that later.
Yes. You have to address the civil matter of the custody issue with your attorney, okay?
Understood, yes, ma'am.
All right, Ms. Ferguson, what day can this come back on? And Mr. Jimenez, I'll put in there waive fees because he's not working.
So just procedurally, the court is making that change. And will that mean that he would be released?
As soon as he has the GPS, yes. All right, we're going to come back on June 20th for discovery and for the state to make an offer.
And we have tendered an offer, Your Honor, that we need to discuss discovery.
Right.
That's correct.
All right, so I hope you understand you are not to have contact. If you do, things may turn out differently. All right. And what is that RIP? We're off the record. What is that RIP, Roman?
My little brother, he died.
Oh, okay. I'm sorry to hear that.
Appreciate you.
All right, thank you.
Thank you, Judge. May I be excused?
Yes. Who's here on Stephen Harden?
0790.
All right, we're here because there are CPS records that are needed.
Oh, but there's not.
Yeah, well, Your Honor, we did attempt to order those, and it was confirmed by one of our investigators that the FPS was not called to the scene, although there was a child in the home. So those records are non-existent.
Okay. No CPS records. All right, so there's no other outstanding discovery then?
Not that I'm aware of, Judge.
All right, State, have you tendered an offer?
I'm reviewing the case now to tender an offer to Mr. Myron.
All right. All right, so State, you're able to tender the offer today or no?
I should be able to tender an offer today.
All right, so the offer is going to be tendered today. We're going to recall this back in 2 weeks for a plea deadline date. Ms. Ferguson, can I have a 2-week plea deadline date for Mr. Harden? All right, we'll come back on June 12th, and that will be your plea deadline date. Is your client anticipating being released from custody?
I don't think anybody's posting his bond, Judge, that I'm aware of.
All right, Ms. Ferguson, on Mr. Harden, can you give them a reset form just in case he's released? Daniel Ortiz. Where's Mr. Ortiz?
Judge, he's not on the docket today. He's on the docket for next Tuesday morning.
All right.
And I had sent an email to see if we can continue that, get a reset for another day, maybe even the next day. I'm be out of town beginning tomorrow through Tuesday.
All right, Ms. Ferguson, which date is this set?
Oh, well, no, it can't be Monday. It's holiday Monday.
No, it's Tuesday the 30th.
Oh, there we go. Sorry.
All right, are you able to have your client in here tomorrow?
Oh, I don't know, Judge. I'm not sure. I'll be out of town tomorrow. That's
all right. So Wednesday,
tomorrow.
The 31st.
Would that be okay, Judge?
Yes.
It'll be the following day.
All right. Norma, call this for June 1st.
Yes, ma'am.
All right. And you'll need to let your client know.
Yes, ma'am. He's I think he's in jail, but well.
Thank you.
But can I be excused?
Yes.
Thank you, Your Honor.
Who's here on Jordan Robbins? Any relation to Baskin Robbins?
No, I don't think so. Maybe.
Well, we're going to find out.
Yeah.
That's the negative.
Okay. Because I would be like, where's our ice
I
cream?
know, because they make bubble gum, which is my favorite flavor, which
Oh, wow. I've never tried that.
I'm weird, I know.
We're saying no.
I mean, I've never tried it. I guess I
It
can't.
has little pieces of gum in it. So
But can we say no to something until we tried it? We're not setting a great example for children. We're like,
I've
try
had
the
bubble
spinach.
gum, like medicine and stuff. I don't.
yeah, I'm a bubble gum freak. So I'm
Well,
gonna
people say-
bring y'all bubble gum ice cream now.
And
Thank
bubble gum
you.
I'll bring normal flavors too.
Okay. All right. So last time we were here, there was discovery, school records, daycare records don't exist. Need a copy of the same. Therapy notes until December. So where are we on all of this? Discovery.
So I think the only thing we were really lacking was that in the SANE, she has the SANE records, but in this particular SANE, for some reason, they did a video of it, which I've never seen before. But we have made some progress because it's not the normal place you request it from somewhere else. And we have made that request and we followed up on it a couple times. I think our next step is we're going to have to send an investigator over there. But we have not gotten it yet.
All right. So what is outstanding?
Outstanding is the therapist Kelly Bernstein records. I think we only have, it stops, I believe.
It's, I want to say it's close to around the March or April time, early March
of last year. Yeah, so the remainder of the Kelly Bernstein counseling records, the state did provide a batch of them, but I gave the dates, I think, to Brittany about what's outstanding.
Okay.
The child's counseling records from school, the SANE video, there was no daycare, and then the cell phone dump that occurred a year ago, we do not have any information on.
And we've reached out to Shirts PD. I think the next step is we're going to have to make an appointment with Shirts PD to go there and look at their file.
All right. So let me just tell you what's going to happen. I'm going to give you guys the final discovery date. It's going to be in 30 days. And any discovery you don't have, if there's a problem with the cell phone dump, whoever that is, people need to subpoena people to be here and do a subpoena Dukas take them and have them bring the records. All right, Ms. Ferguson,
Judge,
yes.
One more issue. Oops, sorry. I did a comprehensive discovery motion and order, and the states agreed to everything within the motion except for one issue. So we needed the court to hear us on that.
Okay, I don't have that motion.
Oh, I have a copy for you.
Can you all look up the motion? What's the title of the motion?
Motion for discovery. May I approach, Your Honor?
Yes, it's a motion for discovery from defense. And may I use this copy?
Yes, ma'am.
All right, so
and I have the order, Judge, that outlines everything that we've agreed to with a few changes that Ms. Mitchell and I have agreed to. There's just one issue. I believe it's the last on page 5, number 2.
All right, so let me go. I think I may have the wrong, you say page 5, what is the?
That's the motion, maybe not the order.
Yes, I have the motion. So which?
You can, it's marked up, but you can look at it.
Okay, sure.
Oh, did I just give for my motion?
All right, I wrote on the one you gave.
Oh, see, I don't have the.
Oh, my gosh, I need a little table right here. Here, hold this.
So all medical and psychiatric reports. Let me see if I can find that in the motion.
Judge, it's on the second, I'm sorry. These pages aren't numbered, but it's on this page, Judge, the third from the last page where it says state evidence, and it is number 2 at the top.
Okay, state evidence. Number 2, the all medical records of Alexandra Reed. Is that the one?
Yes, ma'am.
All right, so this is what we're going to do. Because you all say you have everything else agreed to, if you all can bring me an order of what you all agreed to, and then we'll go on a record and address number 2.
Okay, I have the order of what we've agreed to, Judge.
Okay,
I have
awesome.
it. It has just those minor changes.
Okay, that's fine.
This order that you all agreed to with the minor changes.
On that one, it's stage 5.
Okay.
Number 2.
All right, we're going to go on the record. Court is calling 2022 CR 11724, State of Texas versus Jordan Luke Robbins. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
For the defense?
Amy Owen for the defense.
All right, and are you Mr. Robbins?
Yes, ma'am.
All right, the court has been tendered an order, and it's an order for discovery. State, have you had a chance to review the defense's order for discovery?
I have, Your Honor.
And it's the court's understanding that the items that are marked as agreed with the changes are what the state has agreed to. Is that correct?
Correct.
All right. And state, if you'll initial 1 and 2. And my understanding is that the only disagreement is number 2, and the defense is requesting all medical records of Alexandra Reed, mother of the complainant, relating to her traumatic brain injury, including any and all hospitalizations of Alexandra Reed. Is that correct?
Yes, Your Honor.
All right, defense, it's your motion.
Yes, Your Honor. So I would like to move to admit Defense Exhibit 1. I've already tendered a copy to the state. I don't believe they have any objection.
No objection.
All right.
Your Honor, may I approach?
Yes. Defense Exhibit number 1 is admitted. All right, excuse me, guys. We're on the record, so you all need to either move down there or not talk while we're on the record.
So, Judge, this is the criminal history of Alexandra Reed, and what it indicates is that in December 30th of 2012, Miss Reed suffered a traumatic brain injury as a result of her ag assault with a deadly weapon and an intox assault in Comal County. Now, the research we've done with some of our experts thus far has indicated that traumatic brain injury can result in hallucinations, false memory. Different things can happen within the brain depending on where the injury is. Around the time of this outcry, we see within the civil discovery that we obtained through our civil case that she has been hospitalized. There's payments to emergency room doctors. There was payments to, it looks like, co-pays within that civil discovery right around the time of this outcry. It also can result in seizures, and different things can happen. And so it's our position that this is, our client's completely innocent of this. And so the mother in this case, I believe that could be relevant. I told the state that I'm open and would agree if the court was so inclined. I know it's a big ask because I don't know how voluminous it would be for the court to do an in-camera inspection to see if anything's exculpatory within those records. We're not on a fishing expedition. It's not to just, delve into anything personal about it's simply related to her traumatic brain injury and what could be occurring with mom that we believe that she's coached the child into doing this. So that's the reason why we're asking for it. And I think that it could contain exculpatory information, and the state has objected to that request, Your Honor.
State.
Your Honor, obviously Alexandra Reed is the mother of our victim, not the victim herself. It seems this is an incident from 2012. I don't see how the mother's condition is relevant to what her daughter is saying is her memory. Her daughter doesn't have any injury, the mom does. I'm not privy to their experts and how necessarily this would affect that. Additionally, I don't know exactly what we would even subpoena.
Well, let me ask this. First off, is the mother the outcry alleged to be the outcry?
Yes, ma'am.
All right. So, of course, the court will read, no matter how many pages it is, the court will read whatever is given to the court. As far as the state being responsible for obtaining these records, I don't think that's in their purview to obtain. However, defense, if you want to obtain the records and anybody wants me to review them, I will review them, but I don't think it's because the mother is not the complaining witness. I don't see how it's the state's duty to have those records. And with regards to an outcry witness, the outcry is not to be used as evidence in the sense that it's true. It's merely that this is the first adult that the person told. I understand your argument though, defense.
And Judge, I think the issue with us obtaining them is that she would have to execute a HIPAA release for us to be able to even get those records. I mean, I think if the state subpoenaed them and gave them to the court and the court did the in-camera review, I think that's the only mechanism to be able to get them. I can't just subpoena her HIPAA, her protected medical information.
Well, I think that it can be subpoenaed. And if somebody wants to squash the subpoena, they can bring an attorney in to seek to do that.
Okay. All right.
And then I will hear that motion.
Okay. That sounds fair, Judge.
Okay.
Okay.
All right. So I'll deny number 2. Is there anything else?
I think
It's
that's
just a matter of us getting all the discovery done in that 30 days.
And defense, do you want to withdraw defense's exhibit number 1?
I will withdraw it.
All right. Any objection?
No.
All right. So Dinah, defense exhibit number 1 is being withdrawn. And I'm going to give you all a 30-day reset. This is the last, well, I'm going to give you all a 45-day reset. Okay. This is the last reset for discovery. If there is something that someone is not turning over that everyone feels should be turned over, those persons need to be subpoenaed. If it is not done and we go to a jury trial, then things may end up being excluded.
Understood, Your Honor.
All right, Ms. Fergus, can I have a 45-day reset on Mr. Robbins?
July 13th.
All right, July 13th.
Sounds good.
All right, just get a reset form and then you all excuse.
Thank you, Judge. Maybe be excused.
Yes.
Thank you.
Who's here on Fidel Ayala?
It's a case that was on the trial the last few days. Sealed, 2 sealed motions.
Okay. And you already have a reset date to come back, is that correct?
We do in impact court. We are on the trial lineup for impact on the 12th, June 12th.
Okay, I have 2 motions, but it appears to be for the same.
They are different people. They appear similar, but on the second paragraph, I believe it's a different doctor.
Okay.
One's a private investigator. One is a clinical psychologist.
All right, I'm signing the document, and of course, before they seal them, you need to get a copy.
Yes, Judge.
All right, they'll hand them to you and you can take it to the back.
Thank you, Judge.
You're welcome.
Can we give them the file or no?
Are you okay with them having the file in the back?
Yeah.
I will walk it back.
Yes. All right, thank you. Who's here on Francisco Angel Martinez? Where's Mr. Martinez? Come down. All right, what are we here for?
Good morning, Judge. You had asked for this setting that we convey a plea offer and tender a discovery acknowledgement to the court.
All right, and do I have the discovery acknowledgement?
Yes, for my case, yes.
I'm holding it in my hand. All right. And so was an offer tendered?
Yes, Judge.
All right, Mr. Martinez, how old are you?
19.
19?
Yes, ma'am.
All right, Ms. Ferguson, I want this recalled in 30 days for a plea deadline date. I'm giving you extra time because I realize that you're young. Okay?
Yes, ma'am. I appreciate it.
All right, what date? All right, so we're going to come back on June 22nd. On that date, you need to let the court know whether or not you're accepting the state's offer. If you choose not to accept the state's offer, then we'll give you a trial date and the court will not consider any plea bargain agreements after that point without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, ma'am.
All right. Is there anything else?
Yes, Your Honor. We had filed a motion to reduce bond in this case. I would just want to address that today.
All right, Ms. Ferguson, because we're in jury trial, Judge Nahara will have to hear this.
Good.
All right, and they'll, I think he should be able to hear it today.
Okay.
And Ms. Ferguson, if you'll send the email to Judge Nahara.
Yes, ma'am, I just need that motion.
Okay, I will give you, it's in the file. And you only have it on the 0792, is that correct?
We'll probably want to have that done on all of them. What I can do is if we can actually possibly set that next week.
Send it over to the coordinator.
Okay.
Someone that contact both of you.
Okay. That's fine.
I don't know Judge Nahara's schedule, and I don't know what their schedule.
Who's here on Fortunata Alvarez?
I'm ready, Your Honor.
All right, if you'll come forward.
Thank you.
Court is calling 2022 CR 8768, City of Texas versus Fortunata Alvarez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
James Seeloff.
Are you Mr. Alvarez?
Yes, ma'am.
Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Mr. Alvarez who was placed on community supervision in 2022 CR 8768 for the offense of felon in possession of a firearm on December 1st, 2022 for a term of 3 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. Violated condition number 4 in Bear County, Texas. The defendant, Fortunato Alvarez, did then and there fail to report to the supervision officer as directed for the months of January and February 2023 in violation of condition number 4.
How do you plead to that? True or not true?
Your Honor, we'll waive the remaining violated conditions.
Any objections?
No objection, Your Honor.
Did you understand by pleading to violation of condition number 4, the court could find it true, grant the motion, sentence you to 3 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there an agreement?
Yes, Your Honor.
What is the agreement?
Is to deny the motion to revoke and continue the individual on his probation. Looks like transfer the case to the residing county with no virtual office visits. And if his address is in Bear County, impose the original 14 gangs division program.
Your Honor, he has moved. That's the problem with this whole thing. What county is that?
Howard County.
Howard.
That's where I never moved. That's where I originally
Well,
was
that's
from.
where he lived his entire life.
And what place is Howard County? What city is that?
Big Spring, Texas.
Give her the other big city.
Midland is right by it as well. It's 45 minutes away from Big Spring.
All right. So you're all agreement to transfer to Howard County and then no virtual reporting?
That's correct, Your Honor.
Probation? Is this probation's recommendation?
Yes, Your Honor.
All right. Are you asking the court to follow that agreement?
Yes, ma'am.
All right. Then the court will deny the motion, alternate conditions to transfer to Howard County in Big Springs, Texas. And there's to be no virtual reporting. Defendant to report in person only.
Thank you very much, Your Honor.
All right. All right, Miss, we're off the record, Mr. Alvarez. You're going to have to do better from here on out. Every decision you make, you need to ask yourself, could this decision result in me going to prison for 3 years? You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you very much, Your Honor.
Regina Hendricks.
Your Honor, she was here and she left the shirt. And I made an announcement and she did not answer. She was already gone.
All right. She has I issued a previous bond forfeiture for her.
And I fell on my sword and begged and pleaded, and you gave her a bond.
All right. Court is calling 2021 CR 1164 and 2022 CR 1897, State of Texas versus Regina Hendricks. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
For the defense?
John Young.
All right. This hearing was scheduled at 11 a.m. Your client left. Did anyone give Ms. Hendricks permission to leave the courtroom? State?
No, Your Honor.
Defense?
No, Your Honor. I was speaking with her in the conference room. I came back in the courtroom. I thought she was.
All right. And Deputy Laura, did you give her permission to leave?
No, Your Honor.
probation?
Your Honor, I in fact told her she was not to leave the courtroom because I was going to get a UA sample, and she left anyway.
People just do not like to give UAs. All right.
Embarrassing, Your Honor.
Okay. State?
State's asking for bond forfeiture on all cases, Your Honor.
All right. That will be granted in each case, and she will be remanded without bond.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
All right. Thank you. Always great seeing you. Are the Magnolias still doing well, Mr. Young?
Mr. Young.
Are the Magnolias still doing well?
The Magnolia is outrageous, Your Honor. Apparently the hot shot iron injection we gave to its roots has just tickled its fancy and it's going nuts.
You know what? I need that information for my mom's Magnolia. What you put on your Magnolia.
The what?
I need that information for my mom because her Magnolia tree is not blooming as it should.
And I guess it's the iron. It's called the hot shot.
Okay, I'm going to let her know.
The summer because it will overwhelm the plant with the heat, but that's why they did it in the early spring.
So it's called hot shot iron.
Hot shot iron.
All right, thank you. All right, have a good one.
Yeah, I got rushed this morning, or I would have brought you a.
Aw, thank you. I think they smell so great.
Going nuts.
All right, who's here? Bye-bye. Who's here on Robert Shanahan? All right, Mr. Shanahan. All right. I have this set on the docket for May 30th.
It was, but I requested a continuance.
Okay. All right. Is this your client?
Yes.
All right. He is connecting to audio. All right. Where are we on this case?
Your Honor, I did just find out about some additional discovery earlier this week. So in the interest of judicial economy, I was hoping that we could reset it. I won't have had time.
What's the new discovery?
It's 5 videos.
And what are the videos? Oh,
this is Daniel's case.
Yeah, I mean, but what videos are they?
I don't know.
All right. Do you have the videos now or have access to them?
I believe we just got access to them today. I just needed some time to go over those videos with my client. As you can see, he does live out of town. So I just wanted to have.
Ms. Ferguson, can I have a 30-day reset on Robert Shanahan, please? All right. We'll come back on June 27th for discovery.
May my client and myself be dismissed?
Yes. Oh, the 22nd?
Yes.
Oh, it's the 22nd. All right, Mr. Shanahan. You're muted.
Okay, sorry about that.
Yes. All right, Mr. Shanahan, we're going to have you come up by Zoom on June 22nd. As long as we are into the discovery status, you can appear by Zoom. But once we get to the point where the state is making plea offers and I'm giving you a plea deadline date, you're going to have to make time to come here, okay?
Yes, Your Honor.
All right, thank you. You're excused.
Thank you. Have a good day.
All right, you too.
Bye-bye.
Joaquin Mendez.
He's the no-show judge.
All right, who's his attorney?
His attorney is Mr.
All right, Joaquin Mendez is in federal custody. So state, do you have any update on Joaquin Mendez? He's in federal custody?
No, I don't, Judge. I'm sorry. I just, so you just said that.
No problem. But if you can look into that, Ms. Ferguson, can I have a 30-day reset on Joaquin Mendez? All right, we'll come back on June 22nd.
Okay, good.
Unless he's been released from federal custody, but that's what I have. Albino Acuna. Who's the attorney for that?
If he can zoom in, County Judge But he said he's tried to get a hold of the time and he hasn't been answering.
All right, Norma, let's recall this tomorrow and tell his attorney he needs to be here. And tell them exactly at 9 a.m. Christopher Dunning. And who's his attorney? Thomas Healy. All right, we're going to go on the record. Court is calling 2023 CR 3065, State of Texas versus Christopher John Dunning. Can I have parties announced for the record for the state? Defense is not present. The defendant is charged with the offense of assault, family choking, strangulation. This hearing was scheduled at 11 a.m. It is now 12:26 p.m. Deputy Laura, has Christopher Dunning checked into court? And did you make an announcement?
Yes, I did, and there was no answer.
State?
State would be requesting a bond forfeiture, Your Honor.
That'll be granted. He'll be remanded without bond. If he makes an appearance, the court will reconsider. Anthony Davis.
Hey, Judge, I'm here on that.
Yes, what is happening with Mr. Davis?
Mr. Davis has picked up 4 new assault cases. I've spoken to the mother. The mother has
Is he in custody?
he's in custody.
All right. So are you on all the cases?
Not 100%.
No, yeah, I don't think he's conflict with us.
All right. So if you'll confer.
Yes, sir.
Who's here on John Sanchez?
I'm here going there.
You have been waiting patiently.
I've got more time than I do life, Judge.
See, you're like me. We're both in the twilight of our lives. Okay. All right. So we were here last time in April. Discovery on Sanchez's phone. And number 2 was the co-actor's records or something. So where are we with discovery?
We're still at the same place, Judge.
Why?
And actually, defense sent me a list of other things that they're asking for this morning.
And I know that you're in trial, Judge. We have a motion to modify pretrial conditions. I think it'll be an evidentiary motion.
All right. You can have that heard with Judge Nahara.
Thank you, Judge.
All right. Ms. Ferguson, on this case, can we reset this for 45 days for discovery? And I'm going to expect movement. And you all need to come together to court on that date with the list of what is outstanding.
Judge, we filed the list with the court.
Okay, awesome. For some reason, the list don't make it in my file.
Well, we'll make sure it gets.
Okay.
We filed. We definitely file a Morton's request. It'll be labeled 1- and then request. And then for our Brady, for our medical records, it'll be labeled 2- and request. And then for Brady, our impeachment, it'll be labeled 3- request. We filed that. We filed that at the inception of our case, Judge.
Okay. All right. So just make sure that things are being checked off that list. So Ms. Ferguson, a 45-day reset, please. All right, we're going to come back on July 15th. I'm going to expect some movement.
I expect movement too, Judge. I don't have much control.
13th. She said 13th.
Okay.
And Judge,
All right.
with that, may I be excused? May I schedule something with Judge Nahara?
Yes, after you sign the document. All right, who is here on Tamia Beasley? Yes. All right, Ms. Beasley, if you could unmute.
Yes, ma'am.
Yes. Okay, let me read that. The supplemental report. Is it the supplemental report?
It's the supplemental report and I emailed you something.
Okay. Oh, I see it here. You just put everything in the email. That is so great. Okay, I see what's going on.
As well.
Okay.
You know what I'm saying?
Okay, well, I'll let you know, Jason.
Thanks. It says adjudicated.
Is it a motion to enter?
In your response to the supplemental report, Your Honor, you
Mhm.
wanted to possibly have her father present.
Yes.
From my understanding, he cannot be present, and Ms. Beasley can expand on why that is.
All right. Ms. Beasley,
Yes, ma'am.
you have issues on your probation. What do you think those issues are?
I have not completed a few things on my probation.
Do you want to go to prison?
No, ma'am.
Then why are you not doing what is being asked of you?
I currently am. I have to just pay my fees, I know, and then I'm currently in my outpatient class that I start on the 12th of June. So
have you turned over information to probation showing
Yes.
that you're actually doing this?
Yes, ma'am.
Your Honor, the intensive outpatient treatment begins with Bear County on the 12th of June.
And I've also completed my drug offender class. I'm trying to see, everybody's saying, like, as far as my probation officer that I currently have says that my parenting class is not on file, which I don't know why, because I had to do my parenting class in order to get my child back in the
complete it?
Yes, ma'am, I have.
Let me ask you, what have you learned from parenting?
I mean, I just learned how to cope with things I have going on in order to take care of my child and make sure she has a good life.
Well, what I'm getting here, which I have an issue with, is that it appears that you keep following your boyfriend wherever he may be.
No, ma'am, that's not what's going on.
No, that's what it says here. It says you were supposed to be in Pflugerville. And then you left Pflugerville. Then you returned to Bear County to live with your boyfriend.
Mm-hmm.
So then Travis County closes the case. Mm-hmm. Then in April, you said you're returning to Travis County because your boyfriend has a job in Austin.
Yes, ma'am. That is my boyfriend that I'm currently pregnant by. And that's the only reason why I moved to Bear County back there, because that's where he was at. And this is not the person that it was that I got in trouble for or nothing like that.
No, it appears that you keep bringing people into your child's life. That's why you have had the CPS case. That's why I ordered parenting classes, because you keep putting boyfriends before your children, because you keep moving from place to place. I am sure, how old is your oldest child?
She's 5.
I am sure your 5-year-old is probably saying, please, can I just be in a class with classmates and know these people and not be moved from place to place? You have your core person. Your core person is your boyfriend. Your child would like to have, if Susie's her best friend, she would like to know that Susie's going to be my best friend tomorrow, because I'm not getting moved from place to place because some boyfriend is going from job to job. And that's what you're doing. And you keep changing addresses, and the court is not having that anymore. What are you doing with your life other than following your boyfriend around? Do you have a job?
Yes, ma'am, I do.
So why do you keep following your boyfriend around? What is it he find a job wherever you are so that your child is not uprooted constantly?
Well, as of right now, Your Honor, my child hasn't started school. So I felt like this would have been the most reasonable time to do this, to move wherever the job was better at. I work from home, so it's not really just too much of an issue for me.
No, not for you. It's an issue for the child. And I don't think parents understand. Basically, your lifestyle for your child is not stable for her. Adults are always making moves to benefit themselves. And in the background, they say, oh, well, it's benefiting my child because I'm going with this new guy and he has a job here. So we're going to have a better living situation. That's not stability for your child. So now she's made friends wherever she made friends. And then she's moving to a whole nother city, have to make all new friendships. When you have your core connection is this boyfriend that you're following around from place to place. And you're following people from place to place and not receiving permission from the court to do so. You are on paper. And that means that when you're on paper, you follow the rules that I give you. You don't up and leave from place to place. And it appears that you've moved like maybe 3 different times without the court's permission. And you're not doing what you're supposed to be doing. And what great job did your boyfriend have that you moved to Austin?
He's a teacher, Your Honor. He coaches as well.
Do we have any proof of that?
No, Your Honor.
We have 0 proof of that. And I'm telling you right now, you are coming back to live with your father, the child's grandfather. And I'm sure that was the person that CPS had as your, what is it called?
Safety.
Yes, safety person. So you're coming back to move with that child's grandfather, and that is where you are going to be. And if you're going to be living with this boyfriend, then you need to provide information to probation, what his name is, where he works, and who is he? Because I don't know.
I have spoke to Miss Callie Jones. Miss Callie Jones had him email her a letter of where he works and who I'm staying with, and that he provides everything as for me as far as paying the bills and stuff. So that email has been sent out, and I actually have the email as well.
I don't have that information, and I did not approve of that. So you're coming back to live with your daughter's grandfather.
But Your Honor, as of right now, I cannot do that because my father has a restraining order because he tried to shoot me. He has a felony right now of trying to do that. So
really, is that what we have?
He's from what Miss Beasley reports is he's currently or was currently in jail for.
Do we have information of that?
That's what I don't have it offhand, Your Honor. I'd have to kind of research that a little bit.
Okay, because I don't have any documentation of that.
I know that that's what Ms. Beasley told Officer Rodriguez as well.
Well, if that happened in Bexar County, there should be some sort of documentation of that.
Excuse me, it didn't happen in Bexar County. It happened in Killeen. That's where he lives. That's where he never lived in Bexar County.
Oh, well, it still should be easy enough for us to find that as well. So where did this supposedly happen?
In Bell County, yes.
All right. We're going to find that out.
Okay.
Your Honor, if I may.
Yes.
So if she has completed the classes that were mandated, the parenting program, the drug course, we just do not have any type of documentation of that.
All right. So this is what we're going to do. We're going to reset this because I want information on her father. And she's going to provide all that documentation. And if that documentation is not provided, then a warrant is going to be issued for your arrest if you don't provide this documentation to probation that they're saying they do not have. We're going to come back. Ms. Ferguson, can we bring this back on June 1st? All right, we're coming back on June 1st.
I have a question, Your Honor. So with the probation officers that do have this information, I'm just trying to figure out why it's not getting back to you that do have the documentation of stuff that I finished.
All right. Well, I can't answer that question. I'm not the probation officer.
The Bexar County probation does not have the information.
Yes. Bexar County probation has no information.
Okay, because I've had my probation officer with Coppers Cove and Travis County, and those two.
Well, see, here's the thing. The problem is your Travis County, it's closed. You know why it's closed? Because you no longer are there. All these places that you're talking about, probation should have it here or have it there, they've closed out because you leave without permission. And a motion to revoke should really be filed against you, and you should be brought back to Bexar County and brought over from the jail wearing blue, because you are just moving without the court's permission, and you're moving around with a 5-year-old and not providing them any stability, which the court does not like.
It's not about stability. I have apartments. My leases are up. I move. Like, that's just all there is.
Here's the thing. Do you not understand that you're on probation? It's a contract with the court. And if you don't follow the rules I set for you, that you could go to prison. How hard is that to understand? You don't get to move wherever you want to live because you're on probation, or as people say, you're on paper. You don't get to do whatever you want to do. You're supposed to do what the court is telling you to do. And as a part of your instructions, all these places that you're moving to, I didn't give you permission to move to. And then you're moving to them. And then you're just leaving, going somewhere else. And then I get notice that probation and these different cities or counties that you're staying in, they're closing it because you moved somewhere else. Again, following a boyfriend. I don't know why. It doesn't matter to me if it's boyfriend or girlfriend. People be pinning their hopes on these people. Will you please turn off your phone, Miss Conley? People be pinning their hopes and dreams on a boyfriend or girlfriend. They don't have any legal connection with them. They're just following them across the world. So this is coming back on June 1st. And if you're in Austin, you need to get thee to Bexar County, because that's where that hearing is going to take place. It's not going to take place by Zoom. And your boyfriend should be able to give you bus fare or whatever it is to get to Austin.
Yes, ma'am.
Thank you. So we'll see you in Bexar County, June 1st. All right, who's here on Jose Ruiz?
Sorry to bother.
All right, we're here for, the court is going to set a plea deadline date.
We received a plea.
All right, are you all accepting the plea or not?
No.
All right, Ms. Ferguson, set this for a plea deadline date, and this is come back on June 1st for a plea deadline date. All right, that's your plea deadline date.
Set it here.
Yes.
Thank you very much.
Thank you.
Sorry to bother you. Thank you.
Carlos Madrigal. All right, counsel, today is the plea deadline date.
Yes, Honor. Last time we were here, Judge, the court indicated that, well, we advised the court that Mr. Madrigal was seeking immigration counsel.
Yes.
He has spoken to an immigration lawyer, I think last week it was finally, that they were able to meet. The immigration lawyer is asking for a number of documents. It's an unusual situation just because it appears he may be a citizen.
Okay.
But he needs, the immigration lawyer is advising us that he needs time to research that particular issue, Judge.
And what time is he asking for?
He's just asking for whatever time the court's willing to give, Judge.
All right.
They've already started reaching out to collateral sources.
All right, Ms. Ferguson, recall this in 3 weeks for a plea deadline date.
Thank you.
Sure. Mr. Madrigal, do you need an interpreter or no?
No.
All right, thank you.
June 20th.
All right, we'll be back on June 20th. Ms. Ferguson will give you your reset form.
Thank you. We also have another issue.
Yes, Your Honor. Additionally, we did receive CPS records in between the last court date and this court date. So we are filing a protective order to release those to Mr. Hernandez.
Okay, thank you.
Thank you.
Thank you.
Okay, thank you. All right, who is here on Anthony Davis?
That's me, Judge. State has agreed to have him screened for drug court, and once that's done, hopefully we'll be transferring.
All right, Ms. Ferguson. The state is asking that come down, Mr. Davis. They're asking that Mr. Davis receive a screening for drug court.
Yes, ma'am.
So if we can recall this in 2 weeks for a contested hearing.
Okay.
And probation, can you do a referral? Thank you.
June 8th.
All right, we'll be back on June 8th.
All right, thank you, Judge.
Thank you.
Take care. Thank you.
Oh, I'm sorry.
All right, anyone else left on the docket?
One second, Judge. I don't think so, but. You can have them send up.
Oh, sure.
If you want to copy this.
Yes, please. Thank you.
What? Just two people.
Who's that?
No, it's not gonna be, it's just for.
Okay.
And Judge, Alex Martinez, that was the one where he was on deferred for ag assault, and then we indicted an at-large that predated it. And so I've reached out to the victim, they haven't called me back. So it might be better to like do it tomorrow or something.
Okay. All right, Ms. Ferguson, on Alex Martinez, we're going to recall that for tomorrow. And then Katrina Mendoza, just put that down for tomorrow as well.
And she's the co-defendant with the one that you just gave a plea date on 2 weeks.
You know what? Put it on the same date as that then. What date is that? All right, we'll come back on June 1st. And then Isabel Garza, that is Mr.
That was David
Garcia,
wasn't it? Because he was found incompetent yesterday.
Okay.
He's ready for that.
What date do you want to recall?
Want to do 45?
Yes, let's do 45. Because of the nature of the charge, she doesn't have to go to the state hospital.
July 13th.
All right, we'll come back on July 13th. All right. And then we will be back to start jury trial at 1:30. Who are you all here for? All right, that has been reset.